Welcome to the Private Practice Startup Podcast, where we help mental health professionals grow their dream practices and live a life they love. We chat with successful private practitioners, business coaches, and marketing experts, bringing you tons of practice building tips. We invite you to take advantage of our private practice paperwork and our signature marketing e-course. And we have a gift for you. This is the exact methodology we use to create our six-figure private pay practices and have helped many other therapists do the same. Go to privatepracticestartup.com and on the homepage, click the button to download a free copy of your dream private practice playbook. Now on to today's episode.
Hey everybody, welcome back to another episode of the Private Practice Startup Podcast. We hope that you joined us last week as we talked about a very important question I constantly see in our Facebook groups, which is how do you navigate cancellations in private practice? So we share with you our journeys and what we do and how we've mastered really navigating cancellations to really reduce the number of cancellations that we get in private practice, but also set a boundary and hold clients accountable to their work and our time. So join us as we talk about that. Today, we welcome Devin Miller of Miller IP Law in Utah, and we're going to be talking about how to protect your private practice brand. As crazy as it seems, we've been podcasting for over 5 years now. We have not talked about this. And interestingly enough, Kate and I are right in the middle of this process ourselves with the private practice startup. So this is going to be a great conversation. A little bit about Devin. Devin loves startups. He runs his own patent and trademark law firm to help startups and small businesses. He founded his first startup while earning his law and MBA degrees. And since then, he's founded several 7 to 8 figure startups and has enjoyed every minute of it. So welcome, Devin.
Thanks for having me on. I'm excited to chat about brands and trademarks.
Well, we are excited too. And I'm going to be curious as to what exciting energy you bring to this, right? Because most people are like, this kind of sounds a little dry. So we're going to have you put it on for us in just a short minute. So we want to take a quick moment to thank our sponsor for sponsoring this episode.
If you're a private practice owner, this is for you. Running a business is just plain hard. Endless to-do list, employees to take care of, and your ever-present bottom line. So first of all, kudos to you for staying on top of it. I want to tell you about Gusto. Gusto built an easier and more affordable way to manage payroll, benefits, and more. They help over 100,000 businesses with tasks like automated payroll tax filing, simple direct deposits, free health insurance administration, 401ks, onboarding tools, you name it, Gusto made it easy. And they really care about the small business owners they work with. Their support team is attentive and helpful. And since money can be tight right now, you'll even get 3 months free once you run your first payroll. Just go to gusto.com/PPS and start setting up your business today. You'll see what I mean when I say easy. Again, there's that 3 months free. Go to gusto.com/PPS.
Devin, we always love to know a little bit about who we're talking to. So how in the world did you get started in the field of law and MBA?
It's a long question. Probably take up the whole podcast. So I'll try and simplify it or streamline it just a bit. But so I ended up getting 4 degrees, which my wife always jokes is 3 degrees too many. So I was undergraduate. I did electrical engineering as well as Mandarin Chinese, with the really focus for my career was going to be on electrical engineering. And I was getting towards the end of engineering, and I kind of looked and said, I like engineering, but I don't really want to be an engineer, in the sense that I didn't want to be, a typical engineer. You're a very small cog in a big wheel. It takes you years and decades to work up to where you're going to have an impact on the company or have any real say. And I'm saying I don't know that part of the career path really entices me. But I like engineering, liking to figure out how things work. And so I was kind of at the crossroads of, I thought doing a startup and business and that side was interesting, and also saw the legal aspect of doing intellectual property or patents and trademarks and other things, of kind of interweaving the legal and the engineering aspect was also interesting. So rather than choose one or the other, I went and did both. So that's where I got the MBA and the law degree. And I've really been kind of chasing both passions ever since. And so, as you mentioned, started my first business while I was still earning both of the degrees. I've done several startups and continue to be actively involved with them ever since. And then I've also been a full-time lawyer. So I worked with some larger law firms for about 6.5 years of my career. decided I wanted to switch things up, do my own practice, and be able to focus on the startups and small businesses as the clientele, and then been doing that ever since. So that's a much more miniaturized version of a much longer journey, but that gives you a little bit of insight.
So what was your first startup?
Yeah, so first startup, again, it's a long story. I'm not trying to give my whole story of this, but so I was doing, kind of give you context, at the time I was doing the MBA as well as the law degree, so I was studying 2 degrees. I had a 2-year-old. We just had a newborn. I was working 20 hours as a law clerk. And then in the midst of all that, it was either an email or a flyer. I can't remember which, but it was basically, I saw one and was, hey, come enter, join the group and enter a business competition. I said, oh, that sounds like fun. Why not? So it was kind of one of those multidisciplinary where they had, engineers, and they had their business people, they had attorneys, they had designers, and nobody knew each other. You formed a group and you came up with an idea and entered into the competition. So first year we entered it in, and it was a device or a way to make gym bags less smelly, and thought it was a fun idea. It didn't go anywhere. So we got all kind of it took second place and we all parted ways. But we were all juniors at the time, and the next year we got back together and said, well, we don't really want to pursue that idea. I don't think it would go anywhere. So why don't we kind of brainstorm again and start over? And so we came up with some really just dumb ideas like self-packing boxes and other things that would never work. But in the midst of all that, I had started, and I love to run and to exercise and that. And so I'd done my first marathon recently. And so, one of the things I didn't do well is I didn't hydrate very well, and I didn't drink as much as I should have. So I said, it'd be really cool if you could have a watch that would let you know what your hydration level is, or be able to let you know when you're getting dehydrated. Rewinding, this is in the days, Fitbit wasn't a thing, Apple Watch wasn't out there or anything else, but I thought that'd be cool. So that was really the genesis, and had the idea. My dad was also an engineer, bounced some ideas off of him, built a prototype with my dad over Christmas, and kind of got the prototype up and going, entered in the competition, took second place, which I'm still bitter about, but got to the end of that and bought out my business partners because we were all going to go to different areas of the country and wanted to continue on. And that was kind of the first startup I really got going. And that one's still in different iterations, still going today and still an active business.
Wow. Very cool. That's exciting.
That was my first entree into doing a startup or a small business.
I like how you say, we built a prototype over Christmas. I think of the companies that we've created, and it's they don't all happen that fast.
It was a very crude. It was basically just is there any way to actually do this that might actually work? And so we had an idea of how it might work. We built up a very crude prototype and then started testing it, and it worked to a reasonable degree. And then we, tweaked it and modified it and did it from there. But it was kind of just, hey, let's see if there's any way that this actually works in reality.
Interesting. Well, thank you so much for sharing that. And before we jump into really the topic at hand today, let's just take a quick moment for our sponsor.
Is managing your practice stressing you out? Try Therapy Notes. It makes billing, notes, scheduling, and telehealth a whole lot easier. Check it out, and you will quickly see why it's rated the highest EHR on Trustpilot with over 1,000 verified customer reviews and an average customer rating of 4.9 or 5 stars. You'll notice the difference from the first day you sign up for the trial. They offer live phone support 7 days a week. So when you have questions, you can quickly reach someone who can help. You are never wasting time looking for answers. If you're coming from another EHR, they make the transition really easy. Therapy Notes will import your client's demographic data free of charge during your trial so you can get going right away. Use the promo code PPS to get your first 2 months for free, or try out Therapy Notes for free, no strings attached, including their very reliable telehealth platform. Make 2021 the best year yet with Therapy Notes.
So with creating these different startups, how do we protect our brand, our intellectual property? So share with us, where do we start with all of that, Devin?
Yeah, I'll set the stage just a bit of, you hear a lot of times the terms intellectual property, you hear patents, you hear trademarks, you hear copyrights, and a lot of times they get intermixed and, hey, I've got a brand, I need to go to get a patent, or I've got a patent, or I got an invention, I need to go get a copy, and they tend to get mixed up. So maybe just as a very quick level set, walking through what each of the terms mean just to help people out there. So Intellectual property is an umbrella term. It basically incorporates multiple different aspects of intellectual property. So it includes patents. Patents are for inventions. You create something, you make something, it does something, has a utility, that's a patent. Trademarks are going to be for brands. So name of a company, name of a business, name of a product, a catchphrase, a logo, anything to do with your branding really falls under trademarks. And copyrights is more for the creative side. So a photo, a picture, a movie, a book, a podcast, any of those type of things that's on the creative nature falls under copyrights. And so those just kind of as a level set, when you're looking at, hey, I've got something I want to protect with my business, you need to kind of look and see which area does it fall under, because they all kind of have different ways of doing it. Now, to your question, on the branding side, that falls under trademarks. And so if you're looking to say, and a lot of times, especially if you're in a service-based business and you're saying, okay, I probably didn't, maybe you invented something awesome if you did get a patent on it. But otherwise, if it's saying we're really more in the service-based business, is a lot to do with our brand and our reputation. We build up a clientele. We build up, maybe we get great reviews online, or, we have word of mouth and people look for us. And that's really a lot of the value that you're building, is that reputation and that brand. And so by that nature, that's what you're going to want to protect. In other words, you don't want someone else, you don't want to put in years of saying, okay, we're going to build up a brand, we're going to get referral base, we're going to get, we're going to get online ratings, we're going to do SEO, we're going to do word of mouth, we're going to do, we're going to do all these different things. And then somebody says, okay, appreciate you building the brand. Now I'm going to do something that's very similar that people are going to think we're related. And I basically get to ride the coattails off of your brand. And so that's where your trademarks come in, is to say, okay, as you're building the brand and a reputation, let's make sure to protect that and create an asset for the business.
Got it. So as therapists, I know many therapists probably have a question like, well, should I trademark? Do I need to? What are the pros, the cons? When do I do it? So help us with some of those questions.
Yeah, those are a lot of good questions. So no, as far as should you, I would look at it and say, where's the value of your business? In other words, if you're just kind of a local mom and pops, and nothing wrong with that, but you serve a local community. So you have, hey, I serve this 10-mile radius, and people really just come in, and that's where the kind of the clientele you're serving. You probably don't need a trademark. You don't need to protect the brand, because it's really just a very small geographic location and area. And it's really not that you care. You wouldn't care if somebody in the next city over, the next town over, started a similar brand, because that's not your clientele. They're not really going to encroach in it. So one is, you're going to have to step back and say, where is it? Who are my clients? Who's the core of my business? Now, on the other hand, let's say, there's a lot of different ways that you can do it. People are now, with COVID, they've shifted online, and they've actually been able to expand their reach. And so they're not just in their geographic location, but they're doing it all over. And so now your brand has a bigger presence than it might have, or otherwise might have previously. Or you're looking to say, hey, I want to start a franchise. I want to have multiple offices. And it's either my own offices, or I want to franchise it out and help other people set it up. And then you are going to go beyond just that kind of local geographic mom and pops type of a shop, but you're looking to build it. That's when you're probably going to want to consider to protect your brand, because as you're going into multiple locations, as you're going online, as you're franchising, then you are building something that is a broader scope, and it is going to be something that is an asset of the business. That when you're franchising, a lot of what you're franchising, you're going to be doing it based on your brand. If you're opening multiple offices, you're really piggybacking off of your original success and your reputation to go into multiple areas or multiple locations. If you're going online and you're going to do, an online service, or otherwise doing it remotely, then a lot of what you're doing is that brand that people find you online, or they find you with referrals, and that's when you're going to start doing it. So with all that in mind, the other question you asked is, when should you consider, or when does it make sense to start doing the brand? When does it make sense to actually or seek after protection there? I always kind of look at it as, if you're getting to a point that it would, for lack of a better word, have an ouch factor. In other words, if you're saying, if somebody were to come along and copy your brand, copy your, your logo, or the name of your business, or your catchphrase, something that is going to, and you're going to say, that hurts my business, that's at the point when you're reaching that level that you're going to want them to protect the brand. On the other hand, you're saying, yeah, somebody comes along and they copy my brand and they, do it in this area. I don't really care. It's not really going to affect my business. I probably wouldn't worry about it. But if it says, no, if somebody came along and they copied the name of my business and the name of my brand, and now it's going to take away from my sales and it's going to make it so I don't have as many clients, then you're going to want to protect it. So I think I hit most of the questions, but if I missed any, definitely let me know.
You did, and it's really helpful to hear you explain this and to explain, the timing of things, because our audience is comprised of therapists in private practice. Some are solopreneurs who just have that one small office. Maybe it's a part-time thing, and it doesn't really make sense for them to go through the process of this. But others who may be group practice owners or plan to expand into multiple locations, then it does make sense to explore the trademarking process. Can you tell us about what that process entails and where to start?
Yeah, definitely. So if you're to say, okay, so we've walked through, you've identified what your brand is, and you're saying, okay, I think I need a brand. First thing I would do is probably go, and you can do it with myself, you can do it with other attorneys, but reach out to someone, just kind of say, or talk with them and just take a few minute consultation or a strategy meeting and just make sure that you're on base and what you're thinking actually lines up. That's probably where I would start, is just to say, before I dive in and actually do it, let's kind of have a sanity check. Assuming that makes sense, then you're going to kind of start with typically I would recommend going to an attorney. They're going to provide, a considerable value, make sure it's done right. But you're going to go and you're going to gather the information you'll need for a trademark. If it was ours, an example, we have a pretty easy online guide that kind of walks you through, hey, what is your brand? What are the goods and services you're going to be using it for? Is it a logo, or are you protecting the word? And then it will kind of walk you through that. And you'll get that. The attorney will typically get that information. They'll prepare a draft of the application. They'll come back to you and say, hey, here's the draft. Here's kind of what we'd recommend. Here's how, what it would look like and how much it would cost. And then you'll get that approved. You'll get it taken care of, and then you file it. So that's kind of the first phase, is getting all the information, working with an attorney, getting it filed. Once you get it filed, then you basically get put in a queue for examination. So when you file a trademark, they're going to look at it basically primarily for one standard. And the standard is it confusingly similar with a brand that's already out there? In other words, their job is to say, if we were to allow this trademark, are we going to be confusing the audience because there's already this brand out there, and now when consumers see that brand and your brand, they're going to think it's the same company, or they're interrelated, or they don't know who's providing the goods or the services. So they're going to say, okay, you file the trademark, it takes about 6 months before examination begins, and they're going to look and say, is that confusingly similar? If it is, then you can't get a trademark because somebody already basically owns that brand, and they're not going to allow two brands to coexist that are confuse customers. If not, if they're saying, no, looks like you're clear, looks like you got a unique brand that's different than what's out there, then they'll go through and allow it. So it kind of goes through a back and forth examination process. Now, if they come back and reject it, it's not necessarily the end of the story. You have an opportunity to respond and you say, no, wait a minute, they're completely different than we are. This one says Nike, we say we're Adidas. And, those are two different brands. Yes, we both make shoes, but nobody's going to think that Nike makes Adidas shoes or Adidas makes Nike shoes, and therefore we're different. And so you have an opportunity to argue or explain or clarify things back and forth, and then you try and work with them to reach a reasonable place. If you can, you can get registered as a trademark. If not, then you simply say it's not a registerable brand. And then you're kind of at the place. Just because you can't get a trademark, it doesn't necessarily mean that you can't keep using your brand. It simply means that you can't protect it. Now, it could mean, I guess, backing up, it can mean two things. One, it can mean that you're infringing somebody else's brand and you have to rebrand or you have to stop using it. Otherwise, you're going to be infringing their brand. Alternatively, just mean, hey, this is not trademarkable. Nobody can get a trademark, and therefore everybody can use it. Nobody can own the brand, and it's kind of the Wild West, so to speak. So that's kind of the different options that you may encounter as you're going through the process. I'll pause there.
So, Devin, quick question. So as you're going through the trademark process and say that there is a brand that's similar to yours, does that brand have to be trademarked for them to say, no, you can't trademark yours? Or you're just saying, even if it's similar, but not trademarked, they might say, you can't trademark yours?
So it sounds like a simple question, but if I can only I'll give you a couple different answers. So, complete aside, if you ever want to know that you have a good attorney, their answer is always, it depends, because they always want to give you all the caveats and the reasons why it could go 20 different ways.
That's exactly like ethics in therapy.
So with that, I'll give you a couple different scenarios. So scenario one is that there was already some brand that's already out there. They started before you did, but they didn't trademark. They didn't file any trademarks. They just simply started their shop and they've been going for a while. So that's scenario one. And I'll walk through what would happen. Scenario two is, no, you have somebody else that did file a trademark, that did register it, and now they're out there and they're using it and they own the brand. Those are two different scenarios. So first you'd want to look and see kind of which scenario you're in. Now, if you're in scenario one where you have some business has been out there, it's been using it 20 years and well before you did, they never filed on a trademark. What basically happens is they own the geographic location that they're currently operating in. I mean, they don't have to get a trademark. If let's say they're in Phoenix, Arizona, just to make up a location, and they've been operating in Phoenix, Arizona for 20 years, you come along, you file on a trademark, federally registering it, you can get a trademark that basically covers all of the U.S. except for Phoenix, Arizona. And so in other words, Phoenix, Arizona, the original company, they were using it before you. They get to keep using it in Phoenix. They can't expand outside of Phoenix. You can't go into Phoenix, but you own everywhere else. So that's kind of one scenario if somebody came along before you, but they haven't registered it. Alternatively, now let's say they do own it. They started 20 years ago in Phoenix. 20 years ago, they filed the trademark. They federally own it, or they federally registered it, and they own that brand. And you come along after, and you start using the same or very similar brand. Could be intentional, can be just, happenstance, however it worked out. Then you do have a bigger issue in the sense that if you start using that brand and they own it, you would then be infringing their trademark. They could come after you. They could go after you for trademark infringement. They could sue you. You could get penalties and damages. And so you typically, if you find yourself in the second scenario, you have a couple options. One is you can approach them, see if they'll give you a license. They'll give you an agreement. Maybe they'll say, hey, yes, you can use this brand as long as you're not in these geographic locations. We'll give you a license. You pay us so much a year, and you can continue to use the brand. Alternatively, they may just say, nope, we're not interested. We have high aspirations for this brand. Guess what? You get to rebrand your whole business, and you get to start all over with your branding, which is why you want to do the work and make sure that you actually have a brand that you can protect ahead of time. Because worst thing is if you spend 10, 15, 20 years building a brand, building a reputation, and then you get to come to find out either because you get a cease and desist letter, a lawsuit, or you happen to stumble upon them, somebody else owns this brand. You just now get to rebrand your whole business and get to invest all of that time and money and effort, letting all your customers know, rebuilding reputation, which is a whole lot more expensive than doing it right in the first place. So that's kind of a couple different scenarios depending on where you fall.
I think that's the ouch factor right there.
Yeah, exactly. And but I can have a little bit or a lot of sympathy for a lot of times any startup or small business, because usually how it goes is you're saying, first of all, I just got to see if I can make this work. Can I actually get a business up and going? Can I be profitable and make money? And I'm just a kind of a survival factor. And so, all you're thinking about is getting the business going, getting the clients, and getting money in the door, because that's what you need to get the business going. As you start to hit a level of success, you kind of forget to do the things that you really should have been doing at the beginning, but because you're in the survival mode, you never did. And so then, you get 10, 15, and you always kind of thought, well, I should probably do that at some point. And it always gets on the back burner until you get the ouch factor of somebody comes and says, just so you know, you got a cease and desist letter. They're telling you can't use their brand, and they're probably right. And now you're saying, but I built a multi-million-dollar practice. We have a big clientele, and to rebrand is not going to be trivial and not going to be inexpensive. And you're kind of caught between that rock and a hard space. So what you need to do is, first of all, if you can afford it early on, it's better to get that brand. It's relatively inexpensive, and it's worthwhile to protect it. And, if you can't do it early on, then make sure to have it in your roadmap that as you do get bigger, that you say, okay, once we get 2 years into practice, assuming we've survived and we've made a business, we do need to address this before we get further down the road.
Got it. So what questions didn't we ask that would be important to know as therapists?
So one thing that a lot of times you'll do as, a lot of service-based business is a little bit the same in the legal industry. It's also a lot. My assumption is, you can correct me if I'm wrong, with the therapist, is that a lot of times you'll want to tag your last name or a part of your name with the brand. Now, take my law firm as an example. I named it Miller IP Law. My last name is Miller, and I work in IP law. It's easy to understand. It's very hard to trademark, in the sense that you can, if you're using your last name in your trademark, you have a difficult time getting a trademark for that, because you can't stop other people from using their last name any more than they can stop you from using your last name. So as you're thinking about branding, you have to think, I made the decision that we have a trademark on our logo. So if somebody uses Miller IP Law and it has a similar looking logo, I can stop them from doing that. Could I stop other people from using Miller as their last name? Nope. Somebody else could use another Miller law firm and it's their last name, and they would be able to compete, and I'd have to deal with that. So you are going to look at, one of the things you're going to look at as branding is the more unique, the more different. If you don't use your last name, if you don't use something that's, commonplace, and you make it a little bit more unique, you think of Apple. Apple has nothing to do with consumer goods. Nothing, you don't think of anything. Now you might, because everybody has an Apple, but it has nothing to do with an iPhone. Same thing with a lot of other ones. Pepsi, what does Pepsi have to do? Well, nothing really. Or M&M, M&M is a combination of a couple names. So they're a lot more unique. So the more unique you can get your brand, the stronger it gives your brand, a higher likelihood that you're going to be able to better protect it. So it is kind of a trade-off, and I get it, because I used Miller in my last name because it was a good way to brand the firm. But if you're looking to better distinguish, that's one thing. The other thing we didn't hit on, and I touched on it very lightly, is there is a difference between what's called a word mark and a design mark. A word mark is basically, it allows you to protect the use of the word. So if you're to think of Nike, use them as an example, they have both a word mark for the word Nike. They also have a design mark, which goes towards the aesthetic nature, the look and feel for the Nike swoosh. And so you can actually protect both, because Nike uses Nike all the time for their branding. They also use Nike swoosh all the time for the branding. And so a lot of times when you're looking at a logo, you can protect a logo that has an aesthetic nature, a look and the feel to it, and you can also protect the word. So you also sometimes will have to make that determination as to, how do I want to protect the brand? You can do both. You can do one or the other, and it kind of depends on where the value of your brand is. But that's kind of one other thing to consider as you're looking at your brand.
Perfect. That was really helpful, actually, in talking about the name and the last name, because this is a conversation that we have with therapists all the time. Now we have some added information to share with them, depending on what their long-term goals are, if they're really clear, if they want a group practice, if they want a franchise, if they want to sell it someday, like that stuff is really important to think about. So I really appreciate your enthusiasm about this topic and really educating us and sharing with us specifically about understanding, how to protect your private practice brand. And Devin, what is it that you want our listeners to most take away from your message today?
Now, if you'll oblige me, I have one other thing that came to mind, and then I'll add to that question, which is one other myth or kind of commonplace misconception out there that I just would impart with your listeners is there's kind of the idea that, I don't know where it started, but people kind of think, well, if I register my business with the state, I'm protected with my brand. Or if I go get the URL and the domain or the domain or the website, I've got some brand protection. Just wanted to quickly dispel that myth. Registering your business with the state gives you zero protection with your brand. Getting a URL gives you zero protection with your brand. Getting a trademark doesn't allow you to get the URL. So they're all three separate things that really, you need to do all of them and you want to have all of them, but one doesn't bleed over into the other. So you do want to just kind of keep those straight, that just because you registered your business with the state doesn't mean you have your brand protected. And just because you got the trademark doesn't mean that somebody else doesn't already use the web domain. So didn't mean to derail it or to sidetrack it, but that was just kind of one other thing that tends to come up that people tend to get a bit confused.
No, that was helpful. That was important. So I'm glad you clarified that. And what is it that you want our audience to most take away from it?
All right. Now that I've answered the question you didn't ask, I'll answer the question you did ask, which is, I think the biggest thing, and it's kind of what we hit on before, is there's a lot of demands when you're doing a startup and small business. You're doing a small practice. And really, I think it's analogous with all businesses, that there's always more things to spend money on than money to spend. There's always more things that are demanding your time than you're able to do. And so there's always a bit of that triage list of you're having to juggle multiple balls and figure out what you need to do and when you need to do it. and you're not going to be able to get it all done all at once. You should. And so my recommendation would be to get a strategy or a plan in place and say, okay, first thing I need to do is actually get the business. First thing I would recommend everybody do is get an LLC, an S Corp, C Corp, some sort of business form so it protects your personal assets. That if you do ever get sued or anybody comes after you, you don't put all of your life savings in your house at risk. But once you get that done, start to figure out what do you need to do, what's the most critical to get your business up and going, and what are the things that you do need to do but don't have to be today. Don't just put them off. Don't just forget about them, but kind of have a roadmap. Say, okay, when I hit this milestone, if I'm in business for 1 year, these are the things I need to do. When I'm in business for 2 years, these are the things I need to do. And so at least, you may not be able to get it all today, but you have an idea of a trigger and a plan in place that as you hit these milestones, you're making sure to progressively build your business and protect it. And that's probably kind of generic insight, but I think that's the best thing they can do. And trademarks play into that. Doing branding plays into that. Doing other things as far as a CRM or customer reliant and hiring your first employee, all those play into that. But I think having that kind of that roadmap and plan in place tends to avoid a lot of the issues that tend to get pushed down the road or overlooked otherwise.
Awesome. Thank you so much, Devin, for all your wealth of information and knowledge. And lawwithmiller.com has a great information content on their website, and you can always plan a strategy session. Go to strategymeeting.com and connect with Devin and learn more about what they do and how they can help you protect your private practice brand. We hope that you guys join us next week as Kate and I tackle a podcast on 3 things you must do when starting your private practice. So join us then.
Yeah, Startup Nation, we hope you enjoyed this episode. I know it was really informative, and it's amazing that we haven't had anybody to talk about this topic. So thank you for being here, Devin. And Startup Nation, let's take a moment for our superhero shout out. And this comes from Summer McGowan. Summer says, thank you. I'm really enjoying your podcast and finding it so helpful. I started my part-time private practice last year, and it has grown to the point that I'm taking early retirement from my education to pursue my passion in full-time practice. It's very exciting, but also overwhelming. I am finding a lot of comfort in hearing others that traveled the same journey before, and I know I can learn even more from them. Thank you for all the work that you're doing. Summer, we are here cheering you on. That's so exciting that you're being able to transition into full-time private practice. So congrats to you. And Startup Nation, we hope that you're finding these episodes helpful. We always want to encourage you to subscribe, rate, and review our show. You can find the links to do so on our show notes pages at the website. And, of course, share with your friends and fellow colleagues. And we'll look forward to seeing you on the next episode. Take care, everybody.
Take care.
Thanks for joining us on The Private Practice Startup. Visit theprivatepracticestartup.com for awesome resources, free trainings, attorney-approved private practice paperwork, and so much more.